So I structured this presentation to start off talking about the changes to the Public Health Act. But I think given that we've been talking about my health records for a while, I might skip back to that a bit later and talk about my concerns and some of the issues that came to light when I was reviewing the Act. So I'll just fast forward a little bit to those slides.
Can we get back to the reasonable precautions one? Sorry. Yeah. So I'm sorry I didn't explain in my presentation what reasonable precautions is and why this has become an issue now in New South Wales. So I just mentioned reasonable precautions for those people that should opt in or remain in My Health Act record or opt out. But so this is what reasonable precautions actually looks like from a legal perspective and a clinical perspective.
Yeah. I'll go into detail about that when I'm talking about
right. Sorry.
that. Yeah. So My Health Records. There's some good news as Craig's explained to you the advantages of the system. I'm going to talk about the good news from the legal point of view, which is that there is an offence that's in the Act for unauthorized collection, use and disclosure of health information that's included in your My Health record. And the penalties are they're not very severe, but they're not light. So 600 penalty units is one of the penalties, and then imprisonment for 2 years or 120 penalty units. A penalty unit is $110. So it's a bit of money, and as you can see, 2 years of imprisonment. Now the concern is that there's exceptions. So this Act talks about the user disclosure that's not authorized under Division 2, and Division 2 has a number of exceptions for the way that your information can be authorized, used, or collected.
Vikas, sorry.
Yeah.
What's an example of an unauthorized disclosure? Is that when, like, a doctor might disclose for no apparent reason, or?
Yeah. So anything without consent is an unauthorized user disclosure, unless it falls into one of the exceptions, which there are many of. Yeah. And that's the bad news.
Does that relate to access as well, or is it just disclosure?
So it's use, it's collection, use, and disclosure. Those are the words.
Okay, because there was some report I think that came out from the Australian Information Commission about 113 people were affected by unauthorized access of My Health record in 2016-17. So I'm just wondering what that is as opposed to.
So if someone accesses something, presumably they're using it for something. So I think that the use, collection, and disclosure might encompass access. But I think there's different provisions for access that probably aren't in the scope of this presentation, but there's control levels of who can access what, and there's other provisions for that. But I haven't prepared for this presentation, so I'll take that on this now. So just to go into what is, in what circumstances collection and use and disclosure can occur. So if you look through these, you can see that there's separate provisions for when you can collect, use, or disclose your My Health records within the access controls and then outside the access controls. And Craig used different words to describe those primary uses and secondary uses. So access controls are what you can set up for use by your doctors and pharmacists, and you can put controls on what that data can be used for. So that there's nothing too controversial about those, which is that it's for the purposes of providing healthcare and in accordance with the access controls that are set up by you. Or you can nominate a representative who can access that data, and that's again a process that you have to go through and you decide how that works. Now, if you haven't set up any access controls, there's default access controls that come into place. And as Craig described, those were quite open, so there's some concern in relation to that. So if you are opting into the system or you are using the system and you haven't opted out, then you might want to go into the system and place strict access controls on your specific data if you want it protected and you want it to be used only by specific people. The larger concern is when the collection, use, and disclosure of your data can occur in accordance outside the access controls. So there's a whole list here, and some of these, I'm not going to talk about all of them because that'll take all day, but I'll talk about 2 or 3 of them that are of the biggest concern to me. The second one there, in the case of a serious threat, is one that jumped out to me as being of concern. Now, for collection, use, and disclosure in the case of a serious threat, so a participant in the My Health record system could be anyone. It could be a doctor, it could be a pharmacist, anyone who has access to the system really can potentially collect, use, or disclose your data to someone when they believe that it's necessary to lessen or prevent a serious threat to an individual's life, health, or safety. Now, the words of concern are that the participant has to reasonably believe that that's the case. So, if a doctor believes that there's a threat to a person's life or safety or health, then they can potentially disclose your private health information.
Yes. I'm on the NDIS. Now, I went on the NDIS and then I got kicked off because they said I wasn't sick enough. Right? They had access to my health details, but they just... So my GP then had to give me more information, and then I got put back on. Then I got kicked off again because they said there wasn't enough information. And then luckily Sue Templeton, our federal member, got me back on it, so I'm finally on again. But I got thrown from pillar to post. I said, you've got my health records,
right,
and you don't believe I'm sick. It's like getting the half taxi voucher. Took me 18 months. I said I'd be bloody dead.
and this is your own information, so I guess.
Yeah. They don't believe me.
If we ask questions, this might take a very long time, but am I allowed to?
Yeah, please jump in. I'm happy to kick
So this is the one that I'm most worried about.
Yeah.
Reasonably believes,
Yeah.
so I want to try to make an example of it, but because someone can disclose information if they reasonably believe that there's a threat to an individual's life. If you've got a person who doesn't understand HIV, a doctor who has, say, stigmatised views about HIV,
Yeah.
and he believes that because he thinks someone has transmitted HIV, he can disclose that information. Does that mean that because the test is reasonable belief, that that's not an unauthorised disclosure? That makes it hard to challenge?
So now, the bigger concern here is whether it's reasonable or not.
Yeah.
This provision exists, and a person may think that their belief is reasonable, but and they can go ahead and disclose that information.
Yeah.
And yeah, you can sue them under the Act, and the court might find that belief isn't reasonable, but it's a bit too late by then. That's the bigger concern.
Absolutely.
And as far as what reasonable means, is that the courts have held that a reasonable person can be given the attributes of the person who's in question. So they take a reasonable doctor with similar years of work experience as the doctor who's doing the disclosure. So but that would be a matter that will be litigated later.
Yes.
It'll be too late by the time that's happened, and that's what the bigger concern for me is.
Yes. Okay.
So, that was really the point that I was going to make about it. That those are my concerns. That any participant may have a belief that they think is reasonable. A court may later find that it's not, but it may be too late for them. Now the other thing, in the other relevant bit of the section is that they can also disclose it when it's necessary to lessen or prevent a serious threat to public health or public safety. And again, it's the person who decides what they think is, serious threat to public health or to public safety, with the knowledge that they have. And, it's preemptive. By the time they've disclosed it and you go to court, it's too late. The damage has been done.
All doctors are equal. What about a right-wing Christian doctor?
Sorry.
All doctors are equal.
Yeah.
What happens if we have a right-wing Christian doctor who believes that all gay people should be locked up?
So the test of reasonableness would then kick in, and if his views are based, let's say, on his religion and not science, then that wouldn't be a reasonable belief.
Right. Okay.
But the data's already disclosed.
But the data already disclosed, and that's the big concern. So yeah, we can argue about that.
And so if that data had already been disclosed, and say for example it was disclosed to law enforcement, regardless of whether or not it was considered reasonable to disclose it, could you still be prosecuted with that information?
So in terms of prosecution, the rules of evidence are governed. New South Wales has different rules of evidence to other states, and it's a bit tricky in how the information is obtained. And in the US, for example, if some information is obtained illegally, then they tend to throw it out. In New South Wales, there's a discretion the judge has, and he has to do a balancing exercise between the unfair prejudice to the accused versus the probative nature of the evidence. And it's comparing apples and oranges, really. Is that how do you compare the prejudice to the accused versus the probative nature of the evidence? They're not things that can be compared or balanced. So it's a problem. It's a problem with the law throughout in New South Wales. It's like if someone conducts an illegal search on you and finds illegal drugs, and they prosecute you on the basis of that illegal search, the judge in New South Wales still has discretion whether to throw out that evidence or not, and that's pretty unfortunate.
Following on from that, given the number of criminalisation cases that we've seen where the courts have disclosed the accused details, there seems to be more evidence around there at the moment to say that they potentially would use that information, or is that just speculation?
Well, I mean, it is speculative at this point. I guess the number of criminalization cases has been limited by the fact that there's limited information available to the police and to authorities in a centralized place where they can then make the causative links to prove that it was the accused that was the cause of the criminalization. And that's where this system is really problematic, is that if it's all in one place, then you can sort of track where the person discovered that they were positive, and then what actions they took, and you can sort of make a causal history about that. And that's what it becomes really problematic. Now, in relation to, we would hope that, given that most we have some faith in medical practitioners to not, do this unless there is a serious threat to someone's, health or safety. But the other thing that's prominent here is that, so if you disclose something to a lawyer, we could only disclose that information onwards if there's an imminent threat to someone's safety. So that threat will have to be imminent. And again, there's a choice that we have to make whether we can do that or not. But there's no imminency requirement in this. What if the threat to someone's safety is like 3 months later? There's a number of steps that they could take before that to ensure that, like report them to the panel, or, a number of other steps can be taken. But there's no imminency requirement. This could be a threat to some public safety a year from now or 2 years from now. But, they get excused because they've got a reasonable belief in it.
Is the level of fines or the prison term the discretion of the magistrate?
Yeah, of course. So 2 years.
You're guilty, but we'll fine you $1.
Yes, that's absolutely. You can get a Section 10 where there can be no conviction recorded. That's an option as well. It's the maximum penalty is 2 years, and the penalty units that.
But they don't want to put people in prison because there are too many in there already.
Well,
Hang on, James.
sorry, Jane.
Sorry, but coming back to reasonable belief, and then if there is, it still goes to court and the court finds out that it's not, you obviously point out it's too late by then.
Yeah.
Does the Act detail any specific recourse in terms of miscarriage of justice or compensation, or how that would be addressed?
Well, so
Or is that kind of
so it's unauthorized use.
Yeah.
There's that the penalty that I presented at the start. So there's a criminal penalty and a civil penalty. So you've got that the 2 years and the 120 units versus the civil penalty, which is a bit larger.
So if your data is disclosed individually or however,
Yeah.
then that's the only recourse you've got
Under this Act,
under the Act.
you've got recourse under common law.
Yeah.
So there's a tort for breach of confidentiality under the common law, and then you'd have to demonstrate what the damage is, and you can get damages, and you could seek exemplary or punitive damages as well. So there's that recourse, but under this Act, this is the only recourse. Sorry. Right. Okay. All right. So the other bits that were of concern to me is the collection, use, and disposal of your data for indemnity cover, which is to insurers. Now, currently, if there's a matter in relation to a breach of professional indemnity by a doctor, which basically means that if a doctor is being sued or for negligence or malpractice, the court would then be able to subpoena the records of that specific patient, and they could be used in those legal proceedings for that specific purpose. However, it's more case specific because, and it's also in the patient's interest then for that information to be disclosed, but it would be relevant to those proceedings. However, this section makes it pretty broad, and presumably a practice when applying for professional indemnity cover could give the data of all of their patients to the insurer to be able to obtain that cover. Now, there's commercial uses of that data, but that's a big concern for me as to why it would be needed for the interest of the practice or for the individual. So the only benefit I can see is for commercial purposes. That was one of the concerns that I had in relation to this. Now, this section's phrased a little differently because it refers to disclosure to courts or tribunals, which exists anywhere. Like if a court or tribunal subpoenas medical records, they're able to get those records and order those records into evidence. This is more specific about when it can be disclosed to courts or tribunals for the purposes of this Act. And there's a provision in there which seems like an error, which says that except as mentioned in subsection 1 or 2, a participant or a healthcare recipient cannot be required to disclose their health information to a court or tribunal. So what it's saying is, except for those things, their information can't be disclosed to a court or tribunal, which obviously is not the case because these reasons are quite limited. So under this Act, or for unauthorized access to information, or through the provision of indemnity cover, or to the coroner. So it looks like they've stuffed up the section in trying to basically say that these are the only circumstances that your health information can be disclosed to a court or tribunal. they'll probably fix it later, when it's brought to their attention. But that was just something interesting that was in there. Now, the last bit is what I think everyone has been most concerned about, which is the disclosure for law enforcement purposes. So if the system operator has a reasonable belief that the disclosure, use, or collection of your data can lead to the prevention, detection, investigation, prosecution, or punishment of criminal offenses, breaches of a law imposing a penalty or sanction, or breaches of a prescribed law. So this isn't just talking about breaches of the criminal law. It could be traffic offenses. It could be breaches of immigration law. It could be people overstaying their visas. It could be people working while not having work rights for migrants. It could be HIV transmission. It could be drug use. It's very, very wide, and it could just be one person making a complaint, and the police starts an investigation, and they could request that information.
Currently, sorry, Jane, do you want to go first? So currently, in order to get that information, if the police started an investigation, they would have to subpoena.
A subpoena or a warrant.
Or a warrant, right?
Yeah, a warrant is unlikely to be issued for medical records.
Right.
As a fishing expedition.
Yep.
But if court proceedings are already underway, then they could be subpoenaed.
Yeah.
By a court.
Yes. Okay.
So there's judicial oversight.
Yes, and so judicial oversight, and unlikely to be able to get their hands on medical records just for fishing through an investigation.
Yeah.
But this broadens that, on my reading, do you agree?
Yeah.
Broadens that right out and says basically that they can fish around in all these records to try to find something.
For anything. For anything.
Yeah.
So they can look at your records to be investigating you or any other person.
Yeah.
Or any other person's records to investigate you. It's really, really broad. And it's really a shocking piece of legislation. And probably the piece of legislation that in my not that long legal career I've seen that breaches individual rights more than any piece of other legislation I've seen. So it's shocking, really, is what it is.
So not only would apply to immigration, presumably I would imagine C, protection of public revenue, applies to tax, so then they could investigate anyone associated with you as well.
Absolutely. Yeah, so aiding and abetting is still a crime, and they could investigate that. Now, so you can see there's confiscation of proceeds of crime. That's not so problematic, but the protection of the public revenue. So the ATO could go in there and see your records for tax purposes. I don't know why that would even come up or be relevant. Or
there is an immigration for immigration purposes.
Yeah.
There is that test that they do to protect the amount that an immigrating person would cost the Australian healthcare system.
Yeah.
That seems to me like.
Well, I mean, that systems for immigration. If you're a HIV positive person and you're migrating to Australia, that information is going to go to the Department of Immigration.
It's already out there.
It's already out there. My concern is more for, there are people who overstayed their visas, or have no work conditions on their visas and haven't been complying with them, or are here on student visas and are working more than they should. And a lot of times we get clients who are referred to us by health services before they're, let's say they might be unlawful and they come to us and we help them regularize their status. But if that information goes directly to immigration before they've had a chance to get legal advice, then they could get deported. Their visa options get limited once they're engaged with the system before they get advice. There's a whole range of problems that come with that. Now, for immigration purposes, isn't specifically listed here in the exceptions, but it may be covered by breaches of a prescribed law. So presumably, overstaying your visa could be considered a breach of a prescribed law. So it's very problematic. Now, the only, tiny safeguard that exists here is that this information can only be disclosed by the system operator. Now, the system operator is currently defined in the Act as either the Secretary of Health or a panel or a board that's been created for the purposes of the Act. So there's some oversight in the disclosure of that information, but do we really trust one government department to hide information from another government department?
No.
And you know, because a reasonable belief that it'll prevent crime or detect crime or for the investigation and prosecution and punishment is so wide that, you know, the system operator will believe that it's perfectly within or lawful to disclose that information, and then they'd go ahead and do it. So there's that tiny safeguard that it's not your doctor who's allowed to do it under these circumstances, but it's not, you know, it doesn't give anyone much comfort. So now I'm going to go back to talking about some of the changes, the change in the Public Health Act, Section 79, and then I'll talk about how the My Health Records might intersect with that. So this was the old Section 79, where there were duties of persons in relation to sexually transmitted infections. A person who knows that he or she suffers from a sexually transmitted infection is guilty of an offense if they have sexual intercourse with another person, unless they receive informed consent, and then and the other person's voluntarily agreed to take on that risk. And there's a defense if they've taken reasonable precautions from this requirement. And the maximum penalty used to be 50 penalty units, so it comes to about $5,500. The new section, that's what it looks like. It's duties of persons in relation to sexually transmissible diseases or conditions. And a person who knows that he or she has a notifiable disease or a scheduled medical condition that is sexually transmissible is required to take reasonable precautions against spreading the disease or condition. Now I'll go through what all of these things mean individually. So what's changed? Removal of disclosure provisions. So there's no longer a requirement that you have to disclose your condition to a sexual partner. If you disclose and the other person accepts that risk, that's not a defense, it does not protect you. The requirement is you have to take reasonable precautions. Now, there's, amongst the changes, there's a potential for inclusion of additional medical conditions that weren't covered by the old Act. So I'll talk a little bit about those. There's also potential for inclusion of methods of transmission in addition to sexual intercourse, like mother-to-child transmission, which weren't covered by the previous Act, but could be covered by this one. And there's an increase in penalty, of course. Now, we're supportive of the change from what it used to be for these reasons, that the disclosure requirement placed the legal responsibility for preventing transmission on one person rather than framing it in the context of mutual responsibility. Secondly, disclosure is not a reliable safeguard to transmission. And thirdly, people with HIV are highly motivated to prevent HIV transmission, and the old law implied otherwise. And finally, that the removal of the disclosure requirements brings New South Wales into line with, to an extent, with other states and territories in Australia. So reasonable precautions, what's reasonable precautions? It's not defined in the Act, helpfully. Will vary according to the condition, and so for reasonable precautions to prevent HIV may include treatment as prevention, confirmation that the partner is on PrEP or condoms. These are again based on some information we've got from the Ministry of Health. It's not the law. And this information I should put a caveat on, it's not a substitute for legal advice, but what we do advise anyone in the situation is, if you have one of the medical conditions that we're going to talk about now, to get specific advice from your treating doctor as to what constitutes reasonable precautions in your circumstances. And so only your doctor can tell you what that is, and that's what's going to hold up in a court of law more than these guidelines.
So when the changes to the Act came through, a number of agencies, including Positive Life and HALC, requested more clearer definitions from New South Wales Health legally, so that we knew what we were operating with, and this was as much as we got. We weren't able to get much from them. They weren't willing to take a commitment or provide explicit legal definitions at this point in time.
Reasonable precautions to prevent transmission of hepatitis B may include seeking and receiving confirmation from a sexual partner that they're immune to hepatitis B. Or to prevent transmission of certain bacterial STIs, reasonable precautions may include taking a prescribed course of antibiotics and waiting the appropriate period for it to clear. As I said, consult your doctor for information depending on what condition we're talking about. Now, I'll repeat again, if you are not taking or have not taken reasonable precautions to prevent transmission, informing your sexual partner of the condition and getting consent will not protect you under this provision. So that's very important to know. Now, what conditions are covered according to the Act? Notifiable diseases or scheduled medical conditions that are sexually transmissible are covered. In the past, only sexually transmitted infections were covered, which had a specific meaning. Hepatitis C, for example, was not a sexually transmitted infection, but can be sexually transmissible. So it could be covered under this section, but it wasn't in the previous section. So a notifiable disease, so there's a list here that you can see. I'm not going to read it out, but hopefully everyone can have a look at it. Move forward. Now, as I said earlier, this section could include other means of transmission as well, which is mother-to-child transmission during pregnancy, birth, or breastfeeding, and also the sharing of injectable equipment. The increase in penalties. So previously the penalties were 50 penalty units, which at this time equals to $5,500. Now the maximum penalty is 100 penalty units, which is $11,000, or 6 months of imprisonment or both. Now, I know this all sounds a little bit scary, that it's getting worse, but it's also important to note that so far only 7 prosecutions and 1 conviction for the similar offence that was not the last offence, which had defence for reasonable precautions, but the one before that, which didn't have a defence. So there's only been a total of 7 prosecutions and only 1 conviction under the section. So while it does seem problematic, and it is problematic in a lot of ways, that there is a potential for this to happen, it hasn't happened very much in the past. So it's important to put that into perspective. Now, what we were and are advocating for is something that looks like this. This is from the Victorian Act, and it's principles as opposed to penalties, and which puts it's based on the principle of mutual responsibility. Puts the responsibility on the person with the condition, and also with the person with individuals as to protecting themselves and what steps they can do to protect themselves. And that's what we were advocating for, but unfortunately that's not what we got.
So that's what we had in there when it went up to Minister Hazzard's office as a part of the review process. And the writing group for the changes to the Act changed that without letting us know as it was being approved by Parliament. So, and there was no communication back to New South Wales Health or us as community organisations as this was removed and as the penalties were put into the new Section 79.
This is a good example. This is a good example to show opting in and opting out.
That's right.
They put it under the Secrecy Act.
No, just they wanted to make sure it went through, and they didn't want to let us know beforehand. Otherwise, we would have made too much noise and prevented it from happening. And I think this is the really important point, the penalty stuff. Vic's right, that there haven't been many people charged under these penalties. But the issue now is that information's all there. the information's all there, both within the New South Wales e-health system and also now within the My Health record as that goes live. So even though there hasn't been in the past, the potential risk or opportunity for there to be more prosecutions in the future now seems to be greater.
Yeah, that was going to be sort of my the point that I was going to end with. Thank you, Greg. But you know, amongst that, how it coincides with the Public Health Act, you know, multiple sexual partners, changes in viral load, non-adherence to treatment, not following reasonable precautions, drug use, any contraventions of law you have confided to your medical practitioner about. If this information is in your My Health record, presumably law enforcement agencies can obtain it for the purposes of prosecution under Section 79 or for prosecution for other offences. And that's what is problematic as well. And going back to what I said about, yes, it can be given to law enforcement agencies by the system controller, but when a doctor or a medical practitioner feels that, in their opinion or in their belief, that a person is at risk, you know, there's risk to their safety, their health, or their well-being, that information can be disclosed, and that's, I feel, you know, and I would agree, is the most problematic parts of it.
Is there any distinction between the point of an issue coming up and actually the penalty given to the person, like say, the problem today and we take 1 month to decide? What happens during that time? Is it public news that we're not about it? Is it done on the fly? How is the proceeding?
There's some controls about the disclosure, so I can go back to those. So there's some controls. The collection, use, or disclosure must be necessary to lessen or prevent that serious threat, and it's unreasonable or impracticable to obtain the consent of the person to get that information. So there's some controls, and the collection use has to occur not later than 5 days after the advice is sought from the system operator. So there's some controls about it, but it is discretionary. It's up to essentially the medical practitioner. And as I said, by the time we litigate